Okay, everybody, welcome to this afternoon session on when are conflict waivers effective and when are they not. I have to say I'm shocked at how many of you are here to talk about conflict waivers. It warms my heart, so thank you for coming. And I'm sort of leaning in because I apologize, I can't see that part of the room, so I'm looking at you and I'm trying to communicate with you in spirit. Thank you. I'm Merri Baldwin, and the three of us are all members of the newly formed Ethics Committee of the California Lawyers Association, and we're happy to be putting on this CLE as part of other ongoing activities that we will be doing throughout the year to help make ethics guidance and ethics assistance more easily accessible to all of you. And it really is great to see all of you coming out. I'm at Rogers Joseph O'Donnell in San Francisco, and my practice focuses on issues of attorney conduct, legal malpractice, discipline defense, even partnership law and ethics consultation, that kind of thing. So that's, you can get us, and I also teach at the University of California at Berkeley. And with me are Scott Garner and Karen Goodman.
Hi, I'm Scott Garner. I am a partner with Umberg Zipser in Irvine, California, down in Orange County. As Merri said, I'm a member of the CLA Ethics Committee. I'm a former member and chair of COPRAC, which is the State Bar Ethics Committee, as Merri is as well. And I am currently, my practice currently is representing law firms, lawyers, again, similar to Merri, mostly malpractice defense, State Bar discipline, and a lot of ethics consultation.
Great. Hi, good afternoon. My name's Karen Goodman. I am a principal of my own firm, Goodman Law Corporation. I'm in Sacramento. I have a trial practice that focuses on professional liability and employment matters, and really since probably about 1985, I've done primary work has been involved in the lawyer field. So we're really thankful that you're here. Also for the webcast audience, good afternoon. So take it away.
All right, so today we're going to be covering 4 different topics. First, we're going to talk a little bit about the new professional rules and what the rules say about conflicts and waivers. Secondly, we're going to talk about the very important case, Sheppard Mullin versus JM Manufacturing Company, which is the first case where the California Supreme Court has weighed in on advance waivers. We're going to talk a little bit about the enforceability of waivers with sort of an overview of general principles, and then we're going to talk about some hypotheticals. And we may ask for a show of hands in connection with some of the hypotheticals, and feel free to get answers wrong. We like that. And if you have any questions, we're willing to take questions. I think that we'd like to save those for the end, just so that we can get through the material, and also because of this problem with this giant podium and we're seated and everything else. So bear with us. So let's start with the new professional rules, conflicts and waivers. The other difficult thing, just so you appreciate, is that we can't see the slides. So I can see them on this laptop, but these guys can't see them, so we will all make it through this together. So the new rules talk about consents, and informed written consent in a number of places. And I stress consent because if you look closely at the rules, you are not going to find any mention of waiver. That concept doesn't exist in the professional rules. What we all colloquial call waivers are informed written consent. And so a number of the rules, and particularly the conflict rules, call for informed written consent for a lawyer to represent parties under certain circumstances which are defined as conflicts. One of those places is Rule 1.7, which is conflict of interest for current clients, is how the rule is framed. And let me also, as I sit here, see this little turquoise book? These are the new professional rules and other related statutes that the State Bar has available. Some of you have it in the audience. Good for you. You can pick it up for free at the State Bar's booth. So I can't even recommend this enough. It is so handy. So Rule 1.7, current clients. I won't look at my book right now. The rule basically requires informed written consent first to represent a client where the representation is directly adverse to another client in the same or a separate matter. So when you have direct adversity between two clients, you need to have informed written consent in order to have that to continue that representation. Makes sense. The rule also requires informed written consent if there's a significant risk the lawyer's representation of the client will be materially limited by the lawyer's responsibilities to or relationships with another person or by the lawyer's own interests. So those of you who struggled for years to try to understand and apply Rule 3310 now have the benefit, we all have the benefit, of having a much more clear framework for analyzing and identifying conflicts, and then also for resolving them. So Rule 1.7 is slightly different than the model rule, but most of us agree that it is a vast improvement over Rule 3310, which so many of us struggled for years to try to understand and to apply. So so under Rule 1.7, whenever you have this significant risk that your representation will be affected by some other obligation or relationship that you have, then that's a conflict, and you need informed written consent of your clients. The reason I like the formulation of 1.7 because that the notion of a significant risk of a material limitation to your representation is exactly how most of us think about conflicts. That is what a conflict is. It's when your representation of your client is going to be affected by something else and materially affected. So that's when you need informed written consent. So it's important to understand, of course, what informed written consent means. This is set forth in Rule 1.01, which is the very first rule in the whole sequence. And the rule requires written disclosures to the client of the relevant circumstances and the material risks, including any actual or reasonably foreseeable adverse consequences of the proposed course of conduct. So we had a similar framework in the old rules, but again, this is much more clear for explaining what it is that you have to explain to the client. You have to explain the relevant circumstances and then the material risks of going forward with you as their lawyer despite the conflict that you have identified for them. That's what the adverse consequences are that you have to explain. So this is a very clear formulation of what's required, and the consent has to be in writing. And the first part of the rule defines what the informed part of the rule is, and the second defines that the consent actually has to be in writing. Advance waivers. Again, a term that we all use colloquially. You will not see it in the rule. But we usually use that term to mean the kind of broad waiver that a client will give at the outset of a representation before the conflict has materialized. So it's a waiver, that's a consent that's provided in advance before the conflict has generally occurred. Now, in California, until Sheppard Mullin, we had there was a very limited body of case law that dealt with advance waivers and their enforceability. Scott will be talking about that in a minute. But we certainly had nothing in the rule that talked about advance waivers. Now we actually do. Comment 9 to Rule 1.7 says that advance waivers, it's not how they describe it, it's used a slightly different terminology. I think it's advanced informed written consent to a future conflict is how it's defined in that comment. But it expressly states that such advance waivers are not precluded by the rules. So that's an important development for those of us who, are watching this. But it also goes on to say, the comment, that the effectiveness of an advance consent is generally determined by the extent to which the client reasonably understands the material risks that the consent entails. So it's all about the quality of the information provided, because that's what, of course, turns a consent into an informed consent. So the framers of the new rules, express a pretty clear, a pretty high bar under which advanced consents are going to be examined. And again, this is certainly supported by the case law that we now have. And then the sophistication of the client is relevant to determining whether the client reasonably understands the risks, but the comment doesn't specifically say that the more sophisticated a client, the less detailed, for example, the informed consent needs to be. But at least it's suggested that the sophistication, in quotes, understand, of the client is something that can be taken into account. I just want to focus one other part of the rules that talks about informed written consent and that we think of in terms of a waiver, and that is with respect to Rule 1.9, duties to former clients. Informed written consent is required from a former client in order to represent a client whose interests are materially adverse to that former client in a substantially related matter. So if you've got a substantial relationship between your new matter and something you handled for that former client, you have to get the former client's informed written consent in writing, just as we talked about. There are other places in the conflicts rules where informed consent and informed written consent is spelled out, and specifically in the 1.8 series, which is kind of a hodgepodge of different conflicts rules. There are also various of those which recognize informed written consent as curing or resolving the conflicts identified there. But for purpose of what we're going to do today, it's mostly the 1.7 and 1.9 informed consents that we're talking about. So Scott, you want to talk about Sheppard Mullin?
Sure. So Sheppard Mullin, hopefully most of you have at least heard of Sheppard Mullin case. It's at least among the ethics community, it's been a hotly discussed case and an important one, and one we waited for a long time. So I'll do a very brief summary of the facts before I jump into what's significant about the case. Sheppard Mullin was going to represent a company called JM Manufacturing, a very large company, had general counsel, the whole bit, and they signed him up to defend him in a qui tam action. And they got a engagement letter like they should, and in the engagement letter was what I like to refer to as a pretty generic advance waiver. It's a waiver that essentially says you agree to let us represent somebody adverse to you as long as it's not in a related matter. That's effectively what it said. It didn't identify who that other adverse party might be. So they start the representation. They get pretty far along, Sheppard several $1 million into it in fees, when, because of the nature of a qui tam action, one of the relators on the other side became public, and it was a company called South Tahoe. And it turned out that South Tahoe was also a client of Sheppard Mullin in an unrelated matter. So South Tahoe, when they found out that their lawyers are on the other side of this big qui tam action, they file a successful motion to disqualify Sheppard Mullin. So Sheppard Mullin now is in a position where it's out of the case, but it's still owed about $1 million from its client, JM Manufacturing. So Sheppard Mullin commences an arbitration, because in their engagement letter there was an arbitration provision. They commence an arbitration to recover the money that is owed by JM Manufacturing. JM Manufacturing, for its part, argues, hey, wait a minute, there was a conflict of interest that you didn't disclose to us. The advance waiver is not effective, therefore, your fee agreement isn't worth anything. It's void. And so we shouldn't have to pay anything. Oh, and by the way, all that $2 million or so that we already paid you, we want it back. Well, the arbitrator ruled in favor of Sheppard Mullin. JM Manufacturing then moves to vacate the award, which is rejected by the court. So Sheppard Mullin's sitting pretty here. And now it goes to the Court of Appeal. And that's when things got a little bit bad for Sheppard Mullin. The Court of Appeal said, no, there was no effective waiver. Therefore, there was a conflict of interest, and with a lot of discussion about what it is that voids a contract that's not as relevant here, they said that the failure to abide by the rules of professional conduct, particularly relating to conflicts of interest, voids the engagement agreement. So that A, voids the arbitration provision. So guess what? Everything you just did in arbitration, forget it, doesn't count anymore. And by the way, you're not entitled to recover your fees under the agreement because you don't have an agreement. And then they took it even a step further and said, you can't even recover in quantum merit. In other words, for unjust enrichment. You get nothing. And by the way, you have to return the $2 million or so that you were paid so far. That case goes up to the Supreme Court. The Supreme Court, for the most part, with one exception, which I'll mention in a second, agreed with the Court of Appeal. And what they said, and this is where I think there's some debate about how far does Sheppard Mullin go, but they said, as they're holding, that without full disclosure of existing conflicts known to the attorney, the client's consent is not informed for purposes of our ethics rules. So they made a point of saying that Sheppard Mullin knew, or at least should have known, that South Tahoe was a client. And so that generic waiver should have mentioned South Tahoe specifically. It was a known conflict. So, one question is, of course, what happens if it's not a known conflict? Would that generic conflict waiver work if you didn't know who the other party was? And we're going to get into that in some of our hypotheticals in a little bit. I think probably the answer is no, but Sheppard Mullin, again, could be read somewhat narrowly, although I'm sure plenty of people will not read it that narrowly. I remember at the time thinking this is really not a great test case for advanced waivers, because in most cases you don't know who that adverse party is. Here they actually did. But anyway, so the court said there was a conflict, it wasn't properly waived, so the agreement was void. The fact that JM was about as sophisticated as a client as you could have was of no moment to the court. Now, that doesn't mean sophistication doesn't factor in. As Merri said, it is in the rule now in one of the comments. But when you've got a situation like this, all the sophistication in the world is not going to save that waiver. So again, the fee agreement was invalid. The one bone they threw, I guess, to Sheppard Mullin on the disgorgement issue, they said, look, it's not automatic that they don't get at least quantum merit. We need to send it back to the trial court to decide essentially how egregious, how devious, how bad acting was Sheppard Mullin, and that will determine whether Sheppard Mullin can still recover something for their fees. And again, this is $3 million. So you can imagine this is a serious issue for anybody that's looking to enter into a potential conflict situation and going to rely on a waiver that may not be so good.
And I just want to add one thing, which is to Scott's point that this may not have been the greatest advanced waiver test case. What's always fascinated me about the use of advanced waivers is almost every single large firm operating in California routinely includes a broad advanced waiver in its representation agreement. Those of us in smaller firms may not do that and may not need to and may not think that that's the right way to proceed with our clients. But I can tell you, because I've seen them and I've advised on them, they are routinely used. Yet, we've had so few cases in which a client has contested the enforceability of one of these waivers. That to me is so interesting, because it literally has been in hundreds and hundreds of thousands of client representation agreements. And yet we've had a handful of cases, all in the federal district court in California, some in the northern district, some in the eastern district. And then this is really the first big state case that came along to test advanced waivers. So that's really interesting. But the other point is, I really think that for the purpose of understanding the court's analysis, it's really the withholding of the information about the current conflict at the time that the representation agreement was signed, which explains the court's rationale. You agree, Scott?
I do agree. I think that's really a key. And again, we'll see going forward if, when you don't have that fact, will the results still be the same?
Okay, Karen, you want to talk about enforceability of waivers?
Certainly. So we have a good example. Obviously, the Sheppard Mullin case is a case that those of us that work in this field followed as it went from the Court of Appeal to the Supreme Court, certainly of what not to do. And we can talk about a lot of things that don't work. What I can tell you from what we've seen with the issue of what to put in a document, the first thing really is to disclose what the conflicts are, what the issue, identify the conflict, just fully disclose it, which was the error I think we can all agree Sheppard Mullin made, and what it means, because the important thing, as Merri earlier said, was how it might impact your representation on a go-forward basis. So those of you, and we've all seen them, that have in their file the form conflict waiver, before you send it out to the client, first thing, think about what the actual conflicts are. You have two clients. How, in the circumstance, based on your experience, might their interests diverge? It's not uncommon when we represent the joint clients. My experience is On day one, they all come in, they're completely united. They hate that other guy. They're all in love with each other. It's the greatest thing. Something happens, and then you get the call. Client A calls you up and tells you something and says, don't tell client B. That's a problem. And you know what? That should be addressed at the outset, because it's a waiver. The joint client exception under 962 means everything that client A says to me, I can say to client B. I can't keep secrets. And that needs to be clear. It needs to be clear in writing before the clients are asked to consent to this joint representation. Think about the case as it comes in. If it's an employment case, obviously I do a fair amount of those, and you're representing the company and the alleged perpetrator, obviously 99.5% of the time, when you do that, the perpetrator says it's all a lie. It didn't happen. Company says, I'm going to stand by that person until the smoking gun appears. And then the company says, I hate that guy, I want him out of here. Now, if you haven't disclosed that that might happen, that's going to be a problem with enforcing, considered to be informed consent. You have the experience to know when you're representing everybody has the honeymoon, and during the course of litigation, honeymoon is over. So you definitely need to disclose that the objectives may differ. You may be in different positions during the course of the representation. There may be times that your lawyer may not be able to assert all the defenses on your behalf because it may be inconsistent or hurt the other party's interest. The whole key of the disclosure is that you lay all the cards out on the table, cards face up, so the client knows all the risks. So please, the extent you have, the line that says, I've disclosed to you, there may be a conflict. I don't think there is a conflict. You've consented to that conflict. I don't think you can say, coming out of this, hopefully by 3:15, you've realized that will not work. You've got to tailor it to the specific facts of the case that you know, and make sure the client understands, which gets to the next part of about the written consent, is that you should get that they acknowledge that all the secrets, you can't keep secrets amongst each other, it's a waiver under 962, and make sure your client understands what this means. So there's going to be issues when you're representing a client that has some competency issues. That may be a problem. For many of us that represent clients that English is not their prime language, you need to pump the brakes on this and make sure the client understands it, because guess what? You can have the greatest disclosure, the client doesn't understand it, you're going to be in trouble in terms of being able to give informed written consent. Now, can you get consent by conduct? Because invariably in the work I do, they're all friends. The lawyers are friends with the clients, everybody's good friends, and they say, they all knew I was representing everybody. Well, under the rules, as we're looking at now, as Merri pointed out, it says informed written consent. There are cases with the prior rules that have said by conduct, you've known, it's acceptable, but we haven't tested that, and I don't think you're going to be able to say you can do implied consent and comply with rules that require written consent. So I think that's something for everybody that's in, and many of us have great relationships with our clients. It's why the clients come back to us time and time again with all of their problems. Bear in mind, if it's not in writing and there's a problem, it didn't happen. So when you have a rule that says it needs to be informed, written consent, I think you really run a huge risk of being in violation of the rules when you decide you're going to say, we all know I didn't have it in writing, but they waived any objections. Can the client revoke? Now, we haven't tested that in California yet. The ABA allows it. It's allowed in the ABA rules. I would certainly think that if a client revokes the consent, that I would be hard-pressed to say I'm going to then refuse to allow the client to get another lawyer. So I would be hard-pressed to say I'm not going to consider that revocable. And then the last thing I do want to say, things change during cases. As I said, when something changes, it's addressed in 1.910, a material change in representation, you may need to amend it and provide an updated disclosure. So frequently, you may be in a situation where the honeymoon's great, you've gotten a disclosure, everybody's waived, and then something happens, and you need to lay that out and let the client decide whether they want to stay with you or whether they want to get another lawyer. So those are, I think, the overview, but I would say really in some, throw out all the form boilerplate stuff, it's not going to work. Tailor it to the case. Think ahead, given your prior experience where things go wrong, because they always do, and make it clear. The client, you can't expect you to keep secrets from one client from another. So those are really, I think, kind of the key things you need to think about in having an enforceable consent to potential conflicts or actual conflicts.
One thing I like to do, I think it's a good exercise, is when you're drafting up a consent and you want to make sure you're fully informing the client, I like to write it out as if I am trying to talk the client out of hiring me. Here are all the horrible things that are going to happen to you if you hire me despite this conflict. And that'll force you to think about it. Now, I'm not suggesting that's the letter that you send, but you can imagine, right, the more horrible things you lay out, the stronger that waiver will be. You have to temper that with the fact that you actually want to get hired. But I think it's a good exercise to make you at least think about what those ramifications could be.
I always like it when I advise lawyers, about a conflicts waiver, and I explain to them what they have to tell the client. Well, I don't want to tell them that. I'm like, yeah, well, that tells you have a conflict right there. So, all right, let's start on some of our hypotheticals. Scott, why don't you walk us through this first one?
Sure. So hypothetical one is lawyer is retained by a company, K Corp, to handle a breach of contract litigation. Lawyer pulls one of her law firm's form engagement letters and tailors it to a representation of K Corp. Included within the engagement letter is the following language. I won't read it, but this is a generic waiver, very much like the Sheppard Mullin one we talked about. 6 months into lawyer's representation of K Corp, lawyer is approached by an employee of K Corp seeking advice about a potential wrongful termination action against K Corp. Lawyer tells the employee that she is not willing to file litigation against her current client, smart move, but will review employee's potential claim and advise him on whether it makes sense to pursue the matter through separate counsel. So on those terms, lawyer commences representing employee. So let's talk about what some of the issues are. So first, the question is, has lawyer breached any ethical duties? Well, we look at Rule 1.7, and it says that you can't be adverse to a current client. Well, even though here lawyer is not going to be filing a lawsuit against, her former or her current client, she's clearly adverse, right? She's giving advice that's adverse. So clearly there's a conflict. And then the only question is can it be cured, or was it cured here by informed written consent? So then we go back to the generic advance waiver, and we say, was that enough to inform K Corp of this potential conflict? And I think from everything we've just heard about Sheppard Mullin and everything else, no way, right? This is just an example of how this generic waiver that so many law firms use isn't worth very much. Here's a sort of basic conflict that could come up, and it's not going to protect that lawyer in this situation. Now, one thing I think is interesting is, could they have drafted, they obviously didn't know who this employee might be. But suppose the law firm had a big employment group, and that's really what they specialized in. Could they have drafted it in such a way that maybe didn't identify employee by name, but said, we may be approached by one or more of your current or former employees about suing you for wrongful termination. You consent to us advising that client even though we won't file a lawsuit, or something along those lines. I think that would be a much closer call. I'm not sure what Karen or Merri thinks, but I think that one, you'd have a decent argument that survives, even though you're not naming off who that party is. I don't know if you guys agree to that.
Yeah, I think that's right. I mean, obviously, the more detailed you can be, the more likely it is to be enforceable. And if you can describe, for example, a type of representation or type of conflict that's going to emerge, maybe there are, maybe there's a specific employee that you know is potentially a problem. Maybe there's a competitor, for example, that you represent that, that's not a confidential fact and that you can disclose. I mean, again, the more you can be upfront and clear about this, the more informed that consent is going to be. All right, hypothetical 2. Karen, did you have anything to add?
I mean, obviously, from a practice point of view, I have a real doubt with the wisdom of the lawyer undertaking to represent this employee under any sort of circumstance here. I think this seems like a suicide mission if the said lawyer wants to continue to represent K Corp. This happens, obviously, in closely held corporations quite a bit, particularly when you have a lot of contact with executives, and executives then have employment issues. So, I mean, this is where you have you date myself, the Rolodex of other lawyers. This is not, I'm not sure whether you can draft to get around this one, but that's just my view under the hypothetical given.
Do you really have a Rolodex? Just tell us.
It's buried,
Okay, all
but it's findable.
Okay. All right. Hypothetical 2. Lawyer represents real estate partnership sued for employment discrimination. We don't mean to focus on employment here, but it does lend itself to these hypos. Along with employee who is individually sued. Reflecting the long relationship with the partnership, the waiver reads, quote, clients understand that their interests may diverge. In the event of a dispute or conflict between you, we anticipate that we, law firm, would continue to represent the partnership, notwithstanding any adversity between employees' interests and the partnerships. By your signature below, you consent to our continued representation of the partnership and agree not to assert any conflict or seek to disqualify us, notwithstanding any adversity that may develop. 6 months into the litigation, lawyer obtains evidence that employee harassed the plaintiffs and that partnership has a valid cross-complaint against employee for breach of the employment contracts. Questions? What other information needs to be disclosed to the clients at the outset, if any? Well, that's the central question. Was that waiver, that consent that we just looked at, is that really enforceable to allow the law firm to continue to represent the partnership, sever off the employee, not only for defense of the basic claims, but now also to pursue the claims against the employee on behalf of the partnership? So we've taken it to, a whole extra level. Can this law firm actually be adverse to that employee now going forward? And, I think that we've been talking quite a bit about what needs to be in a disclosure, and I think most of you would agree that cursory disclosure in that consent probably wouldn't pass muster under contemporary standards. Now, I will say that some of that language in the hypo is drawn from the case of Zador versus Kwan. Many of you are familiar with that case. And the waiver in that case was much more detailed, but the court in particular focused on that phrase, notwithstanding any adversity that may develop, and suggested that language was sufficient to inform the individual partner, or I think he actually was an employee in that case, but it was sufficient to inform the individual that down the road, if their interests diverged with the companies, that the law firm could actually sue that employee on behalf of the company. So, some waivers will specifically say that we may actually be adverse to you in litigation, and some waivers won't be that specific. The more specific you can be, the more likely it is that you'll actually be able to enforce it. So, does this waiver allow the lawyer to represent the partnership in the claim against the employee? I think this is a simplified hypothetical, and I think, probably not under these facts. In Zador versus Kwan, the court did allow the law firm, Heller Ehrman, to continue to represent the partnership against the employee. Interesting case. Not only was there a detailed discussion of this waiver and the potential conflict at the beginning, when it did emerge, they sat down and had another long discussion with the employee and got a new conflict waiver signed. And, later, of course, it turns out that the employee had been defrauding the partnership, and I think that also helped inform the court's analysis here. I mean, the employee knew better than anyone else that there might be some potential conflict with the corporation, because the employee knew that he'd been defrauding the company for some time. So I think that definitely impacted the court's approach there. What if lawyer learns about the harassment through a confidential communication with employee, that client, during the course of representing that employee? He says, I got to just tell you, I did it. I feel badly, and there's no way around it, but I did it. Does that allow, that circumstance, can the law firm rely on this waiver to go ahead and sue, turn around and sue that individual on behalf of the company for this conduct that the individual client has confessed to the law firm? How many people just think, sure, the waiver's going to allow them to do that? How many people think, no, that's just not going to happen? You're absolutely right. So the difference is, in the scenario, is the law firm obtaining confidential information from that client that it would now use against that client. That is, I don't think you can really devise a waiver that is going to allow the law firm to do that. Maybe it's possible. I'd love to see it and see the client that'd be willing to sign it. But it'd be very, very hard. So even with the best crafted waiver that's going to allow, specifically by its terms, allow the law firm to continue to represent one of the clients going forward, that's always going to be tempered by what has happened, what information does the law firm have, is the law firm now in a position to use against one of the client's confidential information, and that's going to definitely be considered in determining the enforceability of that waiver. Hypothetical 3.
That's
you, Karen.
Plaintiff sues a physician, his partner, and the medical group for medical malpractice resulting in the plaintiff's child's death. So it's a plaintiff is now bringing a survivor action. Punitive damages are alleged against the physician on a battery theory. A single lawyer is retained to represent the physician, his partner, and the medical group. The medical group and the partner are aware that there have been numerous complaints made by patients concerning the physician's aggressive approaches or treatment with patients before and after the incident. So before undertaking to represent the physicians and the medical group, what must the defense lawyer disclose in terms of the informed consent? So certainly this is a case in which you need to lay out the potential divergent interest. In this case, you have a physician who may or may not, depending on proof, be subject not just to medical malpractice claims, but also punitive damage claims and potential coverage issues as a result. Depending on the knowledge with the numerous complaints, you may have a ratification issue with the partner and the medical group. And there may be incidents where this is a case where you would want to have laid out that these 3 different defendants may become at odds during discovery. They may have different objectives, and this may be a situation where it's advisable that they have separate counsel. Now, obviously, I tend to be of the mindset in a case like this that the physician that is accused of the actual battery certainly should have his own separate counsel. And even if you can construct an informed consent with the sufficient disclosures that might meet the test, the lawyer who's representing these multiple clients under the circumstances is really in a position where it's going to be difficult to vigorously defend all those interests because of the competing interests. And so when Merri originally said, how will my representation be impacted because of the divergent interest, that's what needs to be laid out in writing. So the clients have the choice. And that's really the other thing, is when you're in a situation like this, and this is a real-life example, you need to lay this out in detail and in writing and make sure they have the opportunity, number one, to be able to consult with their own counsel, and if they don't agree with the consent, that they get their own counsel in the representation, as opposed to saying, if you don't agree to this, well, I don't know what we're going to do about defending you. I think you put yourself at risk, what the lawyer does, in coercing consent under the circumstances, because that's not going to be consent. And so that's what would be required for the defendants to give their informed consent. They need to be informed of all the potential foreseeable consequences of agreeing to have a single lawyer represent them. Now, assume that after the initial signed written disclosure, all the parties sign about the potential conflict is made, and that the defendant's consent, discovery has revealed that the partner, one of the defendants, had complained repeatedly to the medical group's management about the physician's conduct and actually had been reprimanded by the medical group for complaining about this patient care. Question: does that advanced conflict waiver that everybody signed at the outset of the litigation, does that protect the lawyer from a potential claim representing conflicting interests under 1.7? I don't think it does. I think you have, under comment 9, material circumstances has arisen. This is a new game. The worst case scenario has actually occurred. And I think the potential has been fully realized under these circumstances. In light of this new evidence, what disclosures must be made to the clients? Now, I know, you've probably gathered this from my view, we need separate counsel. I can't represent everybody. That's my view of the situation. This is not something that you can put a Band-Aid on and fix. Now, my colleagues here may have a different view. And can the lawyer represent all three clients, even if the defendants now sign this new updated amended disclosure document? Well, I guess they can until somebody like JM Manufacturing challenges it later. I'm not sure it's a good idea if I'm sitting in the lawyer's shoes. Mary, Scott, what do you think?
So I guess one problem, Karen, in this hypothetical is that to fully explain to the various clients the consequences of agreeing to joint representation, you would have to play out exactly how what their divergent interests are and how those divergent interests would materially limit your ability to represent each of them. Mm-hmm. Would you explain, I understand you don't think this, in a practical sense, this hypothetical for you is just, kind of made up and you wouldn't pursue it. But going back to the conflict waiver that I think you thought was okay in the beginning of this representation, would you explain in that conflict waiver that by agreeing to joint representation, I will be unable, as your joint lawyer, to advise each of you as to your respective interests against each other or something like that?
Yeah, you definitely need to put that in there, because really what you need to make clear at the outset is I'm not going to be the lawyer that can advise the partner about potential claims against the physician. I'm not going to be the lawyer that can advise the medical group about what their rights may be against the physician, certainly.
So putting that kind of information in that initial waiver also gives the individual clients the information they need to really assess the situation, and I think that's a good example. So this partner who knows that he's complained, who knows in the best way possible, and probably he's in the best position to know that he's got potentially divergent interests from the others, by advising him, hey, if you agree to joint representation, I can't advise you as to your interests individually as against the other two. Then that allows the client to say, wait a minute, I actually probably do have interests that might diverge here. I don't want to agree to this advance waiver. So it's not. we tend to frame these things as, protecting the lawyer. That's just our sort of shorthand for trying to determine whether these are enforceable. But really, these are designed to protect the client, give them the information they need in order to knowingly consent or not. Scott, hypothetical 4?
Sure, and I apologize in advance, this is a long one, but it's really a well-written work of fiction, a little bit like a John Grisham novel, so bear with me here. Lawyers' intellectual property practice includes both drafting patent applications and litigating patent disputes. In 2015, lawyer drafted a patent application for inventor for a type of erasable ink. In 2017, the patent issued as patent number 603509. In 2018, inventor sold all of his rights in the patent to BIC. So the inventor now is really out of the picture at this point. In 2019, lawyers approached by New Pen Company's general counsel about defending New Pen Company in a lawsuit filed by BIC, alleging that New Pen Company infringes the 509 patent. New Pen Company explains to lawyer that it in fact infringes the patent, but that it believes the patent is invalid as a result of inventor failing to disclose to the patent office certain relevant prior art. As a matter of fact, lawyer was aware of the prior art when he filed the patent application, but at inventor's insistence, lawyer failed to disclose the prior art to the patent office. Lawyer explains to New Pen Company that he is the attorney who drafted and filed the patent application. New Pen Company tells lawyer, well, yeah, no duh, that's why I called you, right? You're the expert on this patent. So lawyer drafts an engagement agreement and discloses his prior relationship with the inventor and the 509 patent, and further explains in the disclosure that as a result of lawyer's previous representation of inventor, lawyer might be inclined to pull punches in its defense of the infringement action. New company, through its general counsel, signs the engagement letter. So you've got here a lawyer who is trying to do kind of what I suggested before, right? What are all the bad things that could happen if I take on this representation? I'm going to pull punches. I'm not going to be able to make this strong argument about all this fraud on the patent office because, that was my fraud. So haven't I done everything that I've been advised to do by disclosing all the bad stuff? So let's look at 1.7D. 1.7D said, representation is permitted under this rule only if lawyer complies with paragraphs A, B, and C. These are the ones that give the different scenarios and talk about informed written consent. And 1, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. So if the lawyer doesn't think he can give competent and diligent representation, notwithstanding all the conflict waivers in the world, he can't take the matter on. Here, the question really is this an unwaivable conflict? How many people think it is? I think it is. I think this is one of those situations where no matter how good you draft that informed consent, no matter how many sort of horribles you list that could happen, the lawyer really can't adequately represent that client when to do so would require him attacking his own work product, and in particular in this hypothetical, really making arguments that impugn the lawyer's own work and his own honesty, frankly. So I think this is an example of an unwaivable conflict that no informed written consent in the world is going to fix.
And that's, we got to throw in an unwaivable conflict here because it's really important to analyze the question, not only practically speaking, as Karen suggested through these discussions, do you really want to represent all these clients simultaneously or jointly? Is it really beneficial to their individual interests for you to get this informed consent to allow you to do that? And sometimes it's not going to be when you really think about it in those terms, and sometimes you just can't. You realize you cannot competently represent all of them, even if they all consent. And again, I'd love to see the disclosure that says, you agree to my representing you even though I can't competently do so due to my obligations elsewhere. That's just, it's hard.
And I don't think that's to say you can't ever take on a matter where you might have to address your own work product. So in the same hypothetical, suppose the defense really was non-infringement, right? It's nothing to do with validity or fraud on the patent office. It's just that new pen company's product just does not infringe the patent that this lawyer drafted. Then I think you probably could. I mean, clearly it's a conflict, but I think you probably could do a waiver that would address that.
Maybe. We might get into a substantial relationship problem with the former client.
Well, so the former client here is we've written that person out of this.
Ah, okay, good.
But
All
you're right. But typically, you're right. Typically, in this case, when you've got, if the inventor still has some residual interest, that's a different issue. But here, we've intentionally excluded that from the hypothetical.
It is like a John Grisham novel. Karen, hypothetical 5?
Certainly. So, in hypothetical number 5, a restaurant operator enters into an agreement to open a restaurant near the Staples Center with a retired basketball player providing most of the money. The restaurant operator asks his own lawyer to form the new entity and prepare the operating agreement for the single asset LLC. The lawyer has and continues to provide legal advice for the restaurant operator on a number of other similar ventures. In the operating agreement, the lawyer discloses that she's only representing the LLC. Now, the first question is, what does the lawyer need to disclose to all the members of the LLC at the time of undertaking this representation? So one of the things I would say in this case would be the prior relationship with the restaurant operator definitely needs to be disclosed. It certainly needs to disclose in undertaking once the entity's formed, which is a really interesting issue in terms of who's the client, that the obligations that she has is only going to be for the LLC, and she's not going to get involved in any disputes amongst the various members, which unfortunately happens more often than not. In terms of adverse consequences, we can see, as we think about how many restaurants fail, the likelihood that there'll be a dispute between the operator and the money person is something that's pretty real in the restaurant business. And you certainly would not assume, unless the basketball player, I think Bill Bradley played for Princeton, I think he's one of the few, now I am dating myself, Ivy League basketball players. Most basketball players would not be considered to be sophisticated business people. So you can't really rely upon that notion. So should the lawyer advise all prospective members to obtain the advice of independent counsel before signing the operating agreement? Absolutely, 100%. And frankly, I think this should be done in a separate document before the operating agreement's signed, because typically the operating agreement's 20, 30, 40 pages, and by that time, they're just signing the document. What do you guys think?
So your question was, should the lawyer advise? And of course, it's not required by the rules, so important to note. Should that advice be given just as a way to ensure that the clients have the best information available to them in order to sign? Probably. I actually find it hard to imagine a scenario when lawyers shouldn't advise clients of the right to consult independent counsel before signing some important agreement that compromises their rights. But what if the basketball player is not Bill Bradley or Kobe Bryant, but is some poor struggling person with no money? Would you advise the LLC to actually, or someone to pay for that person to consult independent counsel?
Well, sir, I think it's important to get independent counsel. So if that person, even though it's a little bit of a twist on the hypothetical, doesn't have the sufficient means to be able to pay themselves to get independent counsel, I think that would be okay. It certainly needs to be disclosed, and it definitely needs to be independent counsel, not your friend that you're sharing an office with.
The one thing I would say, and this is true with a lot of these things, and this comes up all the time in these small entities, formations, whatever, is while it's important to document your agreement with your client, to the extent you're not representing everybody in the room, right? To the extent you're representing the owner but not the NBA player who's financing it, you should tell that NBA player in writing that you're not representing him or her. I guess if it's NBA, I guess it'd be him. Because if there's going to be any confusion, if that NBA player is in some of these meetings, and he may say, well, I thought you were representing me too. So I think it's always important, whenever there's going to be any chance of confusion, to not only have this, great agreement with consents and everything else with your client, but to make it clear, preferably in writing, to the non-client, that you are not my client.
That's good. So continuing on our hypothetical, as happens frequently in the restaurant business, assume that several years into the business venture, there's a dispute between the restaurant operator and the basketball player concerning the financial management of the restaurant. Can the lawyer get involved in the dispute between the two individuals, and on whose behalf? That's really the first question. And are there additional disclosure obligations that must be made when the members have an active dispute? So I got to tell you, happens all the time, unfortunately. It's why all three of us are in business. It's not a good idea. Get out. And definitely, you don't want to be taking sides in this closely held entity at all. Additional disclosures, this is where the conflicts have really ripened. So you have additional disclosure obligations that I think need to be made. And I think comment 10 under 1.7 really points this out, before you can continue to represent the entity as these disputes blossom and the honeymoon is now over and the restaurant operator and the basketball player are no longer seeing eye to eye, and they realize why so many restaurants fail. Mary, Scott, do you have any other comments on that?
No, let's go on to our last death knell of this poor relationship.
Okay. Assume that the restaurant operator and the basketball player decide to part ways, and the lawyer prepares the terminating agreement in which the basketball player agrees to buy out the restaurant operator. What does the lawyer need to disclose to all parties in this document? So now we've moved forward.
So let me just ask you, Karen, so in this hypothetical, who is the lawyer representing in connection with this buy-sell agreement?
It's hard to tell, but let's just say the documents will recite, as they all have, that he's only representing the LLC.
Okay.
So the real question is, certainly at this point, we can see that the adverse interests have continued to ripen to the point now that we have the divorce, of the business divorce. And this would also be an example of where you would lay out all the circumstances, and assuming that the lawyer decided that he or she was going to represent everybody on this matter, assuming you could somehow conceivably, you would lay that out. It would be a pretty long disclosure. And certainly the risk of what was happening in this case, whether or not there's a release built in that would release the restaurant operator, might be a problem. There's just a variety of things. And this is one thing we wanted to point out in our hypothetical. What would be meant by informed consent? Because you could very well have said basketball player sign this document. It may not be informed, which is really the point of our discussion.
So one interesting thing when you teach law students, as many of you no doubt do, is when you talk about conflicts of interest in the context of transactions, and when you talk about parties that want to engage in a transaction and they come to a lawyer, is there a conflict between them? And the students will often say, well, no, they both want the same thing, right? And there are lawyers and parties, sophisticated parties, who think the same way. And many law firms in Silicon Valley have managed, to sometimes get in trouble around this, but often not, because everyone actually does want the same lawyer representing all of them. And I think that's testament to, less to the effectiveness and enforceability of conflict waivers than just the business interests involved, where everyone's just willing to go ahead despite, are these enforceable waivers that are in place? I don't know. I'm not, maybe, but maybe not. No one's going to challenge them. So that's where we get to. Hypothetical 6. I'll just start. I think this might be you, Karen. Plaintiff sues a number of healthcare providers after she had her foot amputated, following an infection while recovering from ankle surgery. Don't go to that doctor. Plaintiff's counsel initially deposes subsequent treaters, and the defense lawyer is retained by the insurance company to defend the medical doctors in their depositions. After the depositions, plaintiff's lawyer retained the subsequent treaters as experts. Before trial, one of the defendant medical providers fires its existing defense lawyer and hires the defense lawyer. This is so complicated, I can barely even, concentrate on it to read it. So we are just about out of time, so we're not even going to answer this hypothetical. But what we're going to do is get some quick takeaways from each of the panelists on this last parting thoughts on enforceable waivers.
Well, I think my takeaway is, whatever bad stuff is out there, whether it's the identity of the party or what the bad ramifications could be of representing these people jointly, make sure you disclose that. The worse the fact is, the more important it is that you disclose it.
And I would say take waivers very seriously. Don't treat them as commonplace or template kind of things. And if a waiver gets too complicated for you to even draft, think again about whether you want to represent those clients jointly.
Right, and what I would say out of this is don't assume that the clients that come in one day in the honeymoon period will always be in that honeymoon period. So anticipate that there will be disputes along the way, and make sure your disclosures reflect that.
Thank you very much, everyone.